on an independent inquiry into the alleged use of wiretapping of Northern Ireland journalists. I'll ask the Clerk to read the motion.
That this Assembly recognises the essential role of a free press in an open and democratic society, understands that a vital part of that role is the investigation and scrutiny of public bodies, including the legitimate use and protection of sources, affirms that the press cannot be expected to operate effectively if journalists can be intimidated, harassed or subject to unwarranted or unjustified surveillance, and calls on the Minister of Justice to launch an independent inquiry into the alleged use of wiretapping and other unlawful practices against journalists.
Thank you. I call Matthew O'Toole to move the motion on behalf of the opposition.
Thank you, Mr. Speaker. Moved.
Thank you. The Business Committee has agreed to allow up to 1 hour 30 minutes for this debate. The proposer of the motion will have 10 minutes to propose and 10 minutes to wind. As an amendment has been selected and is published in the marshal list, the Business Committee has agreed that 15 minutes be added to total time for the debate. Before the debate commences, members should be aware that there is an ongoing Investigatory Powers Tribunal hearing about the use of covert surveillance techniques by the PSNI, which is listed for hearing in October. The Tribunal is a court and the proceedings are active for the purposes of Contempt of Court Act 1981, so the matter falls within the Assembly's sub judice rule set out at Standing Order 73. Members should therefore take care with their remarks and remain cognizant of the importance of not prejudicing ongoing legal proceedings. Please open the debate on the motion.
Thank you, Mr. Speaker, and I am glad that you mentioned both the Contempt of Court Act and indeed the ongoing investigation by the Investigatory Powers Tribunal, because it is important that in having this debate we are careful about some of what we say, but also robust in standing for a free press, which is the cornerstone of a democratic society and has all too often in Northern Ireland in the past and today been undermined routinely and structurally. And the matter that we debate first in the SDLP's fourth opposition day is exactly that. It is the compromising, the undermining, the hounding of a free press, which is the cornerstone of any normal democratic society. Mr. Speaker, in many ways, it should be difficult to be shocked in this place. Nevertheless, for many of us, it was genuinely shocking when we learned last year, nearly a year ago, about the surveillance of the phone of Barry McCaffrey, an award-winning journalist. Barry McCaffrey only found out that his phone was being eavesdropped upon when he made a complaint to the Investigatory Powers Tribunal about a separate later incident. That later incident, and the chronology here becomes somewhat complicated, and I won't go through it all in minute detail, but that separate later incident was, of course, the wholly inappropriate 2018 arrest and searches carried out at the homes of Barry and his fellow journalist and filmmaker Trevor Burney. In that case, police were investigating Barry and Trevor's sourcing for their 2017 documentary on the Loughin Island massacre, in which 6 people were killed and nobody was ever charged. It was the most bitter irony that the police arrested those 2 journalists while killers in the Loughin Island massacre, including those who were alleged and named in the documentary, remain at large. Barry and Trevor were doing a job that the criminal justice system had failed to do. They were providing a measure of public accountability for the Loughin Island victims, survivors and their families. And to do that, they were using the most basic, fundamental tool of journalism, the use of sources. The use and protection of sources is not some sinister trick that journalists use to vex public authorities or indeed, Mr. Speaker, to annoy politicians like us. It is a central and critical part of the legitimate work of journalism. And, as I said, journalism is fundamental to upholding a free, democratic society. All too often in this society, journalism, as with other democratic norms, has been compromised. We know that Reporters Without Borders and others cite Northern Ireland as one of the most dangerous places in Europe to be a journalist. We know that we have a litigation regime which is used very often to silence public interest journalism. We also know that in the past, and in the not-so-distant past, paramilitary organisations and other organised crime gangs have used the threat of violence against journalists. So there is a context in this society which is important to acknowledge, which is that we have not been an exemplar in terms of upholding free journalism, but journalism has been critical to us and to this society, both through the dark days of our conflict and in the years after the conflict, in terms of upholding norms, holding all of us to account, and showing us a way to a better, more democratic future. So that is an important context that we set out. I should have, Mr. Speaker, at the beginning of today's proceedings, declared my own interest as the person who founded the all-party group on press freedom and media sustainability. So let's go back to the context of wiretapping of Northern Ireland journalists. Brian McCaffrey learned last year via the IPT that this surveillance had happened. Then more revelations emerged, including earlier this year around the potential surveilling of Vincent Kearney, a former BBC, now RTE journalist. There is a very real concern that the tapping of journalists and others is routine in Northern Ireland. We need to get to the bottom of this. It cannot be acceptable. It simply cannot be acceptable that the police feel empowered to, if this is what they're doing, and we need to understand whether it is, to routinely surveil in one form or another the phones or other digital devices of journalists operating in a free press. Now, I come on to the amendment which has been laid by the Alliance Party. I want to, I hope, build as much consensus as possible in the Chamber today. The Alliance Party amendment, our initial motion, calls on the Justice Minister to set up an independent inquiry. The reason for that is that several organisations are clear that what is necessary now, when I say I'm talking about Amnesty, I'm talking about the Centre for the Administration of Justice, and others are clear that we do need an independent inquiry into the surveillance, the phone tapping of journalists in Northern Ireland. So serious is the issue. It is true to say that the Act that created the Northern Ireland Policing Board does provide the Policing Board with the power to undertake those inquiries. It is also true to say that I understand later this week it will be discussed again at the Policing Board. So I acknowledge that there is some common ground with the Alliance Party. I acknowledge that the Policing Board does have a role to play here. But I do want to hear more from the Minister of Justice when she speaks to the House about her view on this. She has commented on it in the past, and I acknowledge, and I should say up front, I don't think the Minister of Justice, I acknowledge she leads a Liberal party. I don't think there's any doubt that the Alliance Party believes in a free press. But I would like to hear what the Minister of Justice intends to do should the Policing Board, for whatever reason, not decide to undertake a full independent inquiry under the powers that they have, because that is what needs to happen. If it's via the Policing Board, then yes, we think that can be the way it happens. But if the Policing Board isn't going to do it, or if, for budgetary or other reasons, it cannot do it, it does need to be established. And the Minister who should be establishing it is the Justice Minister. So I would like to hear from the Minister in her remarks whether she, in laying, or her colleagues laying today's amendment, whether her view is that there is no possible way that she, at any point in the future, can announce an independent inquiry. Because if we think that if the Policing Board can't, then the Justice Minister should. Because, Mr. Speaker, the seriousness of the revelations that we have heard about today are simply, not just today, over the last year or two, are simply too serious for us to ignore. Barry McCaffrey and Trevor Burney have high profiles, and they have done extraordinary work in terms of high-profile investigative journalism, not just in relation to Loughlin Island, but in a whole range of other areas. They have the profile, and they have the public profile to defend themselves and to make a robust case in terms of their position around the IPT and their surveillance. But what we as an Assembly need to do is to ensure that all those journalists who don't have the profile of Barry and Trevor, who don't have the experience, the confidence that they have, do not feel that they are intimidated into not doing their jobs robustly. It is critically important that we get to the bottom of what has happened over the past decade or more. Were journalists in Northern Ireland routinely surveilled by the PSNI? If so, why? If so, why? I appreciate that there is an ongoing inquiry by the Investigatory Powers Tribunal, and I appreciate the Policing Board is going to discuss this later in the week, but neither of those things, as long as I acknowledged at the beginning, we don't stray into the detail of sub judice matters. It is important that as an Assembly we make clear our position that this is not acceptable, and that should the Policing Board not be able or willing to proceed with a full independent inquiry, then the Minister for Justice will do that. So I would like to hear from the Minister for Justice in her remarks as to whether she intends to bring forward an independent inquiry in the event that the Policing Board can't or won't. I also want to acknowledge the news that came out yesterday, Mr Speaker, which was that the Chief Constable John Boucher has appointed a KC with Amnesty and the CAJ and I think some others advising that KC to review the evidence. That is I would be cautiously positive in terms of that as a step forward, but it isn't an independent inquiry. So while that is a first step towards a proper guarantee that we are not routinely surveilling journalists, it cannot be the end point. I think it is clear that there needs to be an independent inquiry. Yesterday's news was a positive step forward, but we need absolute clarity. We cannot have free press in this society compromised. So I await to hear the Justice Minister's response to what we've discussed today, but I otherwise commend this opposition motion to the Assembly.
Thank you very much, Mr Speaker. Mr Speaker, sorry, I've moved.
10 minutes and 5 minutes to wind, and all other speakers will have 5 minutes. Mr. Dixon.
Thank you, Mr Speaker. You would think after all these years I would know that. Mr Speaker, in proposing the Alliance Party amendment today, I want to extend my thanks to the members for bringing forward this important motion, and also to place on record my thanks and my thanks to my party colleague Dr Stephen Farry for his dedicated work on this crucial issue during his time as a Member of Parliament. However, Mr Speaker, if we are simply to pass the motion, and I think this has been acknowledged, unamended, we would be in serious danger of bypassing and indeed sending the wrong signal to those currently tasked with inquiry into these matters. I don't believe that anyone who believes in good order in dealing with these matters would want to interfere in due process. And that's why we're giving the proposer the opportunity to join us in supporting all the steps required to get it and to deliver a robust inquiry in a responsible way forward. Indeed, as the member proposing the motion has said, this is what I believe Amnesty International have encouraged us to do today, to support a policing board inquiry, and only if that fails to satisfy, then other courses of action may be required, including the type of inquiry the proposer is calling for. Let me make this clear, indeed unequivocally clear. Journalism is not a crime, and a free press is the cornerstone of our free, open and democratic society. Northern Ireland's journalism has a proud history marked by resilience and dedication. Even during the darkest days of our troubles, our journalists have always provided crucial investigative reporting, holding those in power accountable. They must be free to carry out their work without fear or interference, as a society where journalists are silenced is significantly diminished. The amendment which the Alliance Party is bringing today is not just a procedural amendment or adjustment. It is a necessary step to ensure that we uphold the integrity of the investigative process. Rushing into an independent inquiry without exhausting the existing mechanisms would not only be imprudent, but also a disservice to the principle of process. The Investigatory Powers Tribunal hearings are currently ongoing, and it is imperative that we allow these established processes to unfold and await their findings before considering further actions. Moreover, Mr Speaker, let us not forget the operational independence of the Police Service of Northern Ireland from the Department of Justice. The PSNI is, as has been said, is accountable to the Northern Ireland Policing Board, which includes both political and independent representative members, ensuring that our police service is effective, impartial and accountable. The Policing Board is actively addressing surveillance concerns and will thoroughly assess these issues. We must respect their role and allow them to complete their review before the Minister considers any further additional measures. Mr. Speaker, the original motion, well-intentioned, lacks a concrete timeline and doesn't consider the logical and necessary steps required for a thorough investigation. Our amendment calls for the Policing Board to take the lead in this investigation, as it should. Should therefore the review fall short, there will certainly be case for further action, including potentially an independent inquiry by the Minister. In conclusion, Mr. Speaker, while the original motion highlights the importance of a free press and the protection of journalistic sources, it is essential to approach this matter with a clear strategy and respect for due process. So I'd encourage members, including the proposers of the motion, to support our amendment. This approach ensures that actions we are taking will be well informed, appropriate and uphold the principles of justice and accountability. Thank you, Mr. Speaker.
Linda Dillon.
Corlia, and can I declare an interest as a current member of the Policing Board? So we know the two journalists, Trevor Burney and Barry McCaffrey, were victims of unlawful surveillance by PSNI and that they received a substantial compensation after an unnecessarily prolonged period. We know that the PSNI targeted the journalists rather than target their resources to investigating what was revealed in the documentary about the atrocity in Loughin Island, in which 6 innocent people were killed. This raises the question of what do we not yet know? Were there other journalists? Were there NGOs? Were there lawyers targeted by unlawful surveillance? The unlawful surveillance of journalists is deeply troubling and warrants our attention and action. It is vital that we ensure that police powers are not used to break the law. Sinn Féin, along with others on the Policing Board, have raised these concerns repeatedly and have sought answers. This has raised critical questions about the PSNI's conduct and the broader implications for press freedom in our society. The protection of journalists from unlawful surveillance is of utmost importance to our democracy and our values. We need to know how police powers were abused in recent years, how they are used now and how they will be used in the future. We have called on the Chief Constable to address these serious concerns. The PSNI must explain their actions and how police powers were used and why. The Chief Constable must also provide assurances that the rights of journalists, legal representatives and other professionals will be respected and protected at all times. In addition to the severe ethical and legal implications, we must also consider the financial cost of these surveillance activities and the subsequent fallout. The resources used on unlawfully monitoring journalists and paying compensation for doing so could have been better put to use. Recent and indeed ongoing reports have surfaced alleging that the PSNI has been involved in spying on journalists and legal professionals in the North. And Amnesty International has issued a guide for journalists who suspect they have been under surveillance by the PSNI. This again highlights the severity of the situation. The Chief Constable has addressed some recent concerns in his statement yesterday, and a report is coming to the Policing Board on Thursday, and the Chief Constable has made it clear that that report will be published for the public to view. Much more remains to be done to allay public concerns about the use of police powers in recent years. And I note that the Chief Constable has confirmed in his statement yesterday that he is initiating an independent review led by Angus McCullough. Any inquiry or investigation into the use of surveillance must be thorough, impartial and transparent. It should investigate the extent of unlawful practices, identify those responsible and recommend measures to prevent such abuses in the future. The Policing Board has been relentless in pursuing this issue of police surveillance of journalists and lawyers and will continue to pursue it. Sinn Féin will continue to seek answers both through the Policing Board and directly with the PSNI. As Ida B. Wells Barnett, the renowned American investigative journalist and civil rights leader, stated, "The way to right wrongs is to turn the light of truth upon them." Let us honour this principle by ensuring transparency, justice and the protection of those who seek to illuminate the truth.
Robbie Butler.
Thank you, Mr. Speaker. The motion and the amendment before us today go right to the heart of the core values of a free press. And over recent years, and even going back a number of decades, investigative journalism has shone a bright light into the many dark corners across this country and exposed many scandals that the public would never have heard about. The Ulster Unionist Party fully supports our journalists in shining these lights, often done at great personal risk to those who conduct such investigations. We support the press in carrying out their duty, but it goes without saying that this must be carried out in a lawful manner and always performed in the public interest. A free press is an essential part of every citizen's right to freedom of expression. Equally, we support the police in carrying out their duty to protect lives and to prevent sensitive information being leaked, and information that could lead to the collapse of a long-running investigation or, in the worst-case scenario, putting someone's life in danger. Both the police and the press must respect each other's duty to collect evidence that will help put those who do wrong behind bars. It is vital that both the police and press act within the law and respect their boundaries. Another cornerstone of the freedom we enjoy is ready access to legal advice, and what passes between clients and their lawyers must be confidential. For anyone to compromise that rule, it could be damaging to the human rights of an accused person to receive best legal advice and guidance. The police have a range of information gathering methods available to them, and at all times permission to deploy any of these methods is quite properly strictly controlled, and permission is only granted by senior management if legislative guidelines and public interest tests are fully met, and that's the bar that should be met. Given the serious nature of the allegations being made against the PSNI in relation to surveillance methods used by them in relation to journalists and lawyers, then an urgent investigation could be fully justified, and it will be, as the member who moved the motion stated earlier, be very interesting to hear from the Justice Minister in regard to what role that the Policing Board may play in regard to the amendment that has been tabled by the Alliance Party. So both the original motion being proposed by the opposition and the amendment added by the Alliance recognise the same need, but they differ in how it may be set up. And the amendment is correct in stating that the PSNI are operationally accountable to the Northern Ireland Policing Board. However, the original proposal calls for the Minister for Justice to launch an independent inquiry, and perhaps towards the end of this debate we may be able to get consensus, and that would be good. What is important is to clarify exactly what has happened around these allegations that have led to an inquiry being required to establish exactly how the police have acted in relation to these matters, and that the circumstances would be fully explored to ensure that journalists and lawyers, who both offer a vital public service, can go about their work unhindered, and in the knowledge that their endeavours remain confidential. We owe a speedy resolution to these matters to protect journalists and lawyers carrying out their lawful work, but we also owe it to the PSNI to clarify the actions taken by the PSA, particularly to what has been alleged both in press and in this chamber today. It is important that we have public confidence in policing, and equally important that journalists and the legal profession can go about their lawful work in the confidence that our confidentiality is protected at all times. Thank you, Mr. Speaker.
Peter McReynolds.
Thank you, Mr. Speaker, and I rise to welcome today's motion, support the proposed amendment and declare this as a newly appointed member of the Policing Board. The motion is an important one because it reaffirms this Assembly's support for a free press and journalism in a democratic society, a sector all of us make use of every day to keep aware of issues facing our constituents, but also wider society, as we work together to create a Northern Ireland for all. I also agree with the motion that journalists must be free from intimidation, harassment or surveillance, a significant part of UK law through the Human Rights Act, and I think it is fair and essential that journalists are able to freely report on issues of public importance and not be obligated to reveal their sources. This simply would not last very long before the objectivity, truth and justice would fall by the wayside. Having seen the documentary No Stone Unturned many years ago now, and the injustices that took place within it, I think it is also more than reasonable for the sources to remain anonymous for fear of reprisal. What is more important within the circumstances of that particular documentary is access to truth, but also justice for serious crimes that took place. It is against this context that I reaffirm my party's support for those holding power accountable, but also who have been under alleged secret surveillance for human rights and for human rights law. Mr. Speaker, since becoming involved in politics over 12 years ago now, joining the Policing Board recently and chairing the Partnership Committee, I have been impressed by the many police officers I have come into contact with, their commitment to serving their community and the wide-reaching roles they sometimes play as first responders, paramedics, nurses, social workers. However, this gratitude only extends so far, and when serious allegations or concerns are raised, it is essential the rules and appropriate processes are followed, whether that be for what I want to hear or not, to establish what has taken place. For this reason, we have proposed the amendment today, as currently the appropriate process would not be followed under the motion to determine if alleged wiretapping and other unlawful practices have been and are being used against journalists. I share the concerns of the SDLP today. However, to ignore the role of the Policing Board in the present scenario would risk undermining the delicate structures of policing here. So I agree with the proposer of the amendment today, because it would allow us, as a Policing Board, those who are operationally responsible for the PSNI, to be better informed as to what has taken place and to collectively decide as to our next steps, which we may deem necessary to involve the Minister of Justice. Moreover, I am aware the Chief Constable has announced just yesterday a review by Angus McCullough KC and a group of experts and stakeholders, including key, well-respected human rights and legal advocates, to ensure that it is as robust as possible. This will then lead to a public-facing report, and during the work he will be available to the Policing Board for scrutiny and updates. We will likely hear more about this at this Thursday's Policing Board. Once we are better informed as a board from the work of Angus and the experts and stakeholders, we can then decide if it is appropriate for the Justice Minister to conduct her inquiry. It is better we let this week take place, or we risk confusion, overlap, waste of public funds, and quite simply ignoring the checks and balances that are put in place to safeguard and protect the public. Lastly, Mr. Speaker, I was at a strategic planning event last week, and we looked at the last 5 years of policing, the present-day challenges, and looked ahead to the next 5 years of the new policing plan. During the course of the conversations, one of the facilitators asked my table if he knew the challenges facing the establishment of the PSNI on day one on the 4th of November 2001. He spoke about how there were some who feared it would be too risky a decision to take at that time and that a pause would be best. However, brave people opted to stick to the frameworks and plans that had been laid and not to deviate, because the bigger picture was what was important to them and the need to stick to process. Mr. Speaker, for the current challenge facing policing, we must stick to the rules and procedures that are in place to best hold our police service to account and allow the Justice Minister to make a more informed decision should we, as a Policing Board, not be satisfied upon the conclusion of the Investigatory Powers Tribunal and the McCullough Review. Thank you.
Michelle Brownlee.
Mr. Speaker, first off, I would just like to declare that I am a member of the Policing Board also. Democracy is a value that was fought and won a number of times over the course of the last century. Alongside democracy, of course, sits freedom of expression, and that includes freedom of the press. In this Assembly, we must make a firm stand against repressive laws and procedures which stifle both freedom of speech and freedom of expression. No journalist should ever be intimidated, harassed, or subject to any unwanted or unjustified surveillance, and this is completely unacceptable, and of course we will stand against this. Very often in this very chamber, we hear things that we disagree with, and sometimes wholeheartedly oppose. But I would concur with what a famous author, Evelyn Beatrice Hall, once said: "I disapprove of what you say, but I will defend you to the death your right to say it." And we can never let repressive regimes suppress our freedom of speech. We support the Investigatory Powers Tribunal in its work uncovering the truth as regards to these allegations, and we must point out at the moment these are allegations. It should be noted, however, that of course there are some times when issues of the United Kingdom's national security may override such journalistic freedoms. And examples of this, of course, would be the identification of individuals, spying or foreign powers. It should be said, however, that this very much should be the exception rather than the rule. We are content that the IPT should be allowed to finish its investigation, and the subsequent hearing is due to be starting in October this year. As a policing board, we want to oversee this, ensure that everything is fair and balanced and there's a proper investigation. And of course, for that reason, we would support the amendment. Thank you.
Patsy Midlone.
Thank you very much, Mr. Speaker. I rise, of course, in support of the motion and qualify my response in regard to the amendment. A free press is the cornerstone of any democratic society, and that has been repeated multiple occasions here. It is a vital role in speaking truth to power. Journalists not only have a duty to protect their sources, but they also have the legal right to protect them. Surveillance of journalists and their sources has a deliberately chilling effect on the media, a key cornerstone of our democracy. I've listened to the members talk about the amendment, and I trust that the amendment tells us that the Minister won't be sitting on her hands and doing nothing, and instead waiting until the Policing Board decides to ask her to act. And I would put a rider in there, and it's up to the Minister to qualify it, that if she determines that there's any aspect of kicking the tin down the alley, that she will act, and I trust that she will clarify that. I would also argue that indeed the evidence compels her to act now, because this is not simply an operational matter for the Policing Board to review. This is about public confidence that the police will act lawfully, and about how they are held accountable if they don't. It is also, as Trevor Burney, one of the journalists at the heart of this story, has said, about an undermining of freedom of the press in Northern Ireland. Trevor Burney and Barry McCaffrey were arrested in August 2018, and their homes and offices were raided. In May 2019, the Appeal Court in Belfast quashed the warrants for their arrests. The court ruled that there was, quote, no overriding requirement in the public interest which could justify an interference with the protection of journalistic sources in this case, unquote. In July 2020, the then Chief Constable Simon Byrne apologised to the journalists, and substantial damages were paid, amounting to a reported £875,000. This was all in relation to the documentary No Stone Unturned, which my colleague has referred to, which investigated allegations of collusion in the UVF murders of 6 men in Loughinisland in 1994. I have to say it's thanks to the courage and tenacity of both Trevor Burney and Barry McCaffrey that we now know about the industrial-scale spying operation used against journalists here. It is only because the 2 journalists made a complaint to the Investigatory Powers Tribunal in 2019 that a hearing is in fact being held. And it is only because of that hearing that we have evidence of that unlawful spying operation. It is rare for these hearings to be in public, and indeed is an indication of the seriousness of this issue that they are being held in public in this case. But a full hearing won't be held until October, because the initial hearing was adjourned on the first day due to late disclosure of police documents. What has been revealed is truly shocking, though.
Member give way?
Yep.
Would the member agree with me that the late disclosure of documents and the loss of documents is, as we know, when we look at some of the legacy cases, just a complete symptom of the state? And so this is part of the reason why an independent inquiry with statutory powers may ultimately be required.
The member has an extra minute.
I thank the member for his intervention, and I indeed have attended a number of those inquests where that in fact is the case. It's disgusting. That's all you can say about it. And that's why I did qualify remarks at the start for the Alliance Party, that if there is any aspect of this where people are being evasive, where the police are being evasive, and where they are seen to be withholding information or delaying the release of information, that then I ask that the Minister would dutifully act, and respectfully so. For at least a decade, the PSNI unlawfully regularly trawled through the phone data of at least 8 journalists trying to identify their sources. Following their unlawful arrests in 2018, both Barry McCaffrey and Trevor Burney were subjected to covert surveillance in a further bid to identify their source. The Tribunal is also investigating 2 other instances of police surveillance against Mr McCaffrey in 2011 and 2013. The BBC have also instructed lawyers to contact the Tribunal about covert surveillance of Vincent Kearney in 2011, when he investigated the independence of the Police Ombudsman. Mr Kearney is now the Northern Editor with RTE. And the Policing Board has been left playing catch-up on this. It wasn't until September last year that the Board asked the PSNI whether they had conducted surveillance of journalists or lawyers since 2011. It took the police 8 months to produce a report that the Alliance Party representative on the board described, quote, as utterly vague. That report was only produced by the Chief Constable after the covert surveillance of journalists here was made public by the Tribunal in London. It has been reported that as many as 10 journalists and 10 lawyers have been subjected to covert surveillance since 2011. How often, we don't know. The Policing Board is due to meet again this month to receive a further report on the extent of the surveillance of legal professionals and journalists. But this meeting will not be held in public, and it is unlikely that the report will be made public. And, it has to be said, it does not inspire confidence in the Policing Board when a senior member of Sinn Féin on the board had a recent court ruling against him for his own attempt to intimidate and silence journalists with a slap. SLAP, of course, is an acronym for Strategic Lawsuits Against Public Participation, a tactic used by the rich and powerful to silence troublesome journalists. It would be understandable if the public were sceptical about some parties' declaration of support for a free press.
Members' time's up.
Thank you.
Thank you. Thank you. Jerry Carroll.
Mr. Speaker, just yesterday the PSNI Chief Constable John Boucher was forced to deny claims that police had spied on so-called troublemaker journalists. He was forced to refute widespread media reports that the PSNI accessed the phone bill of journalists who play a pivotal role in investigating the crimes of the state. Over 4 weeks after the Justice Minister faced calls to order a public inquiry into these allegations, the Chief Constable has ordered an independent review of the matter. First of all, Mr. Speaker, I would say that journalists will probably, no doubt, welcome any independent investigation that leads to disclosure. But secondly, I have to say that it does not absolve the Minister of the responsibility for calling a full public inquiry with the power to fully investigate these matters. The fact that the PSNI has to deny such spying allegations or order an investigation of any kind points to a complete lack of faith in this discredited police force. When I raised these concerns in the Assembly last month, I spoke to the case of Trevor Burney and Barry McCaffrey, who were pursued by the PSNI for exposing the truth about the Loughlin Island atrocity. Police attempts to prosecute journalists for exposing PSNI collusion in the murder of 6 civilians, in my view, is no accident, Mr. Speaker, and many people will see it as a direct policy of a police force whose dark activities have purposefully denied justice to people from all walks of life. And we don't need to scratch too far below the surface to identify how far it goes, because the PSNI have interfered with attempts to hold the state to account in the past. This is not just my opinion, Mr. Speaker, it's an absolute fact. This is a police force that has harassed journalists to get them to reveal sources which should be protected in any functioning democracy. The PSNI has treated journalists as criminals effectively, seizing journalistic materials and throwing them in cells for trying to investigate the state murder. The PSNI has covered up the collusion of the RUC using PII certificates and all sorts of other dirty tricks to deny justice to families bereaved by state-backed paramilitary death squads. All of this is unacceptable, Mr. Speaker, and time and again the PSNI have proven to be a law unto themselves. I would ask how many more journalists were spied upon. As I asked before, have MLAs been spied upon? Nobody knows the answer to these questions. Will give way, sure.
It's, I suppose in concept of the issues that are being raised refer to actions that the PSNI was taking when the policing board was in situ and actually had responsibility for them. So by asking the policing board to do the investigation, there is a bit of a case of asking them to mark their own homework, and that's why, in the interest of everybody's will to see this determined, actually having an independent inquiry would take that their sense away from it.
I thank the member for his point.
Members, an extra minute.
Thank you, Mr. Speaker, and I totally agree with him. It is effectively like marking their own homework. And just as it was coming on to, Mr. Speaker, I think it is utterly unacceptable that the PSNI Chief Constable has been allowed to take the initiative in terms of investigating allegations of wiretapping of journalists' phones, effectively, as the member said, marking their own homework. And to echo the words of Barry McCaffrey and Trevor Burney, we cannot allow the Chief Constable to pick the referee and set the rules of the game. And I want to reiterate, Mr. Speaker, we do need a public inquiry. We need a fully independent public inquiry with investigative powers to expose the PSNI's anti-democratic activities. The Justice Minister can no longer take a hands-off approach when dealing with this police force. Operational matters, but the PSNI doesn't cut it anymore, Minister. So I support the motion and I oppose the amendment. Thank you.
I call the Minister for Justice, Naomi Long.
Thank you, Mr Speaker, and I'm grateful to the Leader of the Opposition for bringing this important motion before the House, and also to all the members who have participated in the discussions. At the outset, I want to make it very clear that I share the concerns that have been raised widely about the alleged routine surveillance of journalists. Journalism is not a crime, and a free press is the cornerstone of a free, open and democratic society. Although lawyers are not mentioned in the motion, I am also aware of concerns that members of the legal profession have been subjected to similar surveillance, and it is important for me as Minister of Justice to stress that solicitor-client privilege is essential to ensure that we have an effective justice system that secures the trust and confidence of the public. I also note in that regard the Chief Constable's statement yesterday, which sought to provide some clarity on those matters. Journalism in Northern Ireland has a long and proud history, reporting through the darkest days of the Troubles, providing some of the finest investigative journalism anywhere, and never shying away from telling important stories or holding those in power to account. The No Stone Unturned documentary, I think, is a classic example of such investigative journalism. Journalists must be free to do their job to the best of their ability, without fear or favour and without interference. A world where journalists are silenced is a poorer and more dangerous one for us all. I want to turn to the use and oversight of covert surveillance powers in the UK. The Investigatory Powers Act 2016, the IPA, provides a framework for the use of investigatory powers by the security and intelligence services, law enforcement and other public authorities. This is UK-wide legislation dealing, as it does, with accepted matters. These powers cover the interception of communications, the retention and acquisition of communications data, and equipment interference for obtaining communications and other data. The IPA also makes provision relating to the security and intelligence agencies' retention and examination of bulk personal data sets. IPA sections 2, 28, 77, 113 and 114 deal in particular with journalistic information. Given the sensitivity and far-reaching nature of the investigatory powers, they are also subject to robust oversight and regulation, intended to prevent their abuse. The Regulation of Investigatory Powers Act 2000 is the primary regulatory instrument and, again, generally deals with matters which are accepted or reserved. From a justice perspective, this covers the use of the RIPA powers in either a national security or serious crime situation. It provides a comprehensive regulatory structure governing the acquisition of intelligence information. RIPA sections 28 and 32 give the basis upon which surveillance can legitimately be carried out. Oversight of RIPA is twofold. A clear and independent complaints and investigation process is managed through the Investigatory Powers Tribunal, and the Investigatory Powers Commissioner's Office oversees inspection and arrangements for use of RIPA by public authorities. The Tribunal exists to investigate complaints about potential conduct of various public bodies in relation to the public, their property or their communications. The Investigatory Powers Commissioner's Office oversees the use of investigatory powers by public authorities covertly to gather information for investigative or intelligence purposes. Members are aware that the concerns which we are dealing with and debating here today in the House are currently before the Investigatory Powers Tribunal, and as a judicially led tribunal, they are sub judice, as the Speaker has already indicated. With regards to local policing oversight, as I have explained many times in the House, and the member will be aware from his own party's negotiations during the peace process, a key principle of Patten is for policing to be free from direct political influence. The tripartite arrangements resulting from Patten mean the PSNI is operationally independent from my department, but is operationally responsible to the Northern Ireland Policing Board. It is essential that I respect those carefully designed lines of accountability. The Policing Board comprises a balance of political representatives and independent members who are collectively tasked with ensuring an effective, efficient, impartial, representative and accountable police service which can secure the confidence of the public. The Board has an important statutory duty under Section 3 of the Police Northern Ireland Act 2000 to monitor the performance of the PSNI in complying with the Human Rights Act 1998, to which a number of members referred in their contributions. I understand the Human Rights Advisor to the Board will provide his assessment on a report received from the Chief Constable in respect of surveillance of journalists and lawyers at the June Board meeting. It will then be for the Board to decide the next steps. I am assured the Policing Board is holding the Chief Constable to account on this most serious matter. Therefore, it is important in the first instance that I afford the Policing Board the opportunity to thoroughly explore these issues with the Chief Constable. I am also assured that the Chief Constable himself is taking the allegations incredibly seriously and is working closely and cooperating with the Policing Board in its deliberations. The Chief Constable will bring a further report to the Policing Board in the near future, and yesterday announced a further independent review mechanism which he has constructed to examine and address these issues. To set that out in more detail, if I may, Mr Speaker, he indicated that in line with his statutory duties to report to the Board, he had appointed Angus McCulloch KC, a leading special advocate with the appropriate security clearance, to conduct an independent review of any PSNI use of surveillance against journalists, lawyers and non-governmental organisations or any groups that have special status. His role will not extend to anything currently within the scope of the IPT proceedings, as it would cut across matters that are sub judice. He has also, in terms of trying to provide public confidence in the review, pulled together a group of respected experts and stakeholders to be consulted about the terms of reference of the McCulloch Review, and to ensure that the commissioning of the review and thereafter its work properly examines any additional relevant matters of concern. The group and its members are not accountable for the independent review, as that sits with the Chief Constable, but they will be providing advice and direction to the work of the reviewer. The independent stakeholders, as things stand, I believe, are the following: Baroness Nuala O'Lone, former police ombudsman and known to many in this House; Martha Spurrier, who was the former head of Liberty; Patrick Corrigan, Northern Ireland Programme Director at Amnesty International UK; Daniel Holder, Director of the Committee on the Administration of Justice; Alison Kilpatrick, Chief Commissioner of the Northern Ireland Human Rights Commission; David Lavery, Chief Executive of the Law Society of Northern Ireland; and Seamus Dooley, Assistant General Secretary of the National Union of Journalists. As the normal processes of policing accountability to the Board, both directly by the Chief Constable, by their own Human Rights Advisor and by the McCulloch Review, have not yet been fully worked through or exhausted, I believe it would be premature at this stage to consider whether there is further action required on my part. I am not for a second ruling out action in future. Indeed, I have gone to considerable lengths in this chamber when previously asked to say that I believe that should my assistance be required, I will not be found wanting. But I believe that allowing the Policing Board to hold the Chief Constable to account at this stage represents a better use of public money, respects fully the independence and centrality of their role, and has the ability to provide clarity on any outstanding matters more swiftly. That said, I take very seriously my role in maintaining and building public confidence in policing, and recognise that these events impact on that wider confidence. In light of this, I stand ready to support the Board in such actions as it feels are necessary. I also believe that it is important that nothing I do will interfere with or cut across the work of the Investigatory Powers Tribunal, which is ongoing and due to report in late autumn. Finally, with respect to my powers in regard to calling a public inquiry, Section 1 of the Inquiries Act 2005 allows for any Northern Ireland minister to cause an inquiry to be held where it appears to them that particular events have caused public concern. The threshold for what constitutes public concern is not set out in the legislation, but there is Cabinet Office guidance which states that generally an inquiry may be set up to establish the cause of a major disaster, accident or other event involving significant damage or loss of life, to make recommendations as to how lessons can be learned from such an event, to investigate allegations of serious public concern which require thorough and impartial investigation and for which ordinary civil or criminal processes may not be adequate or appropriate. It goes on to state that before deciding to establish an inquiry, a minister must reflect on what other investigatory mechanisms are available. Given the ongoing nature of the deliberations of the Policing Board and of the IPT, it would not therefore be appropriate for me to act in advance of that work concluding. I will, yes.
Mr. Giving way on that point, am I to understand that, given that bit of the Cabinet Office guidance requires or implies that other avenues should be exhausted, Should they be exhausted and there be a view in this House, hopefully with some consensus, that an independent inquiry would add to that, would she be willing in principle to call an independent inquiry in those circumstances?
I've already made my position on that quite clear, that I stand ready to do what is required to ensure public confidence in policing, up to and including a public inquiry, should that be necessary. Finally, any potential inquiry hearing evidence may determine that part of the evidence is outside its scope due to the application of Section 30 of the Inquiries Act. And, Mr Speaker, this is important. The provision states that any statutory inquiry commenced by a devolved minister cannot consider evidence or make recommendations about any matter which is accepted, including national security. It may therefore fall to me to ask someone else to initiate the inquiry at the level where that would be required, so that the full remit of the national security elements of this can be fully considered. I will, of course, keep abreast both of the tribunal findings and the progress of the board's own considerations on the matter. I hope they can provide the robust reassurance to journalists, the legal profession and the wider public regarding the use of these intrusive powers by the police. But I stand ready to offer any such assistance as may be appropriate within the law and within my responsibilities. Thank you.
I call Nuala McAllister to wind on the amendment to 5 minutes.
Thank you, Mr Speaker. I also, at the start of this, want to declare I too am a political member of the Policing Board. The freedom of press, as everyone has said, is paramount to an accountable and democratic society. Alliance have consistently called for this freedom and stood by journalists in the past when they have been attacked, both overtly and in present day for journalists to carry out their duty without fear of prosecution. And it is that element of prosecution which brought us here today, where Barry and Trevor learned that they were subject to surveillance by the PSNI. I want to highlight the work that Alliance have been doing over the past few years since the issue first came to light. Since their arrest, Barry and Trevor were in touch with my Alliance Party colleagues through Stephen Farry and Saoirse Eastwood. They have been in touch with both myself, John Blair, a previous member of the Policing Board, Owen Tennyson, and also our new member, Peter McReynolds. I too have been in touch with Amnesty International, CAJ and others regarding the appropriate steps that we need to take as political representatives and as a member of the Policing Board. It was and remains an outright disgrace that 2 journalists were arrested, and even more questionable as to how this action came about in the first instance. Over the past few weeks, we have become aware that there may be an investigation, a review initiated by the Chief Constable, and as member of the Policing Board, I sought to take on the advice and guidance from those organisations who may be involved in the terms of reference of this review. As a Policing Board member, I was aware that this announcement may come up before the June Policing Board meeting, and I am glad that the Chief Constable sought to make that public yesterday. As I mentioned, I engaged with relevant groups with regards to the confidence in this independent review by the PSNI, headed by Angus McCullough KC, and this can and will be a precursor to anything I or our other Policing Board members will do. The Policing Board, as others have said, has powers, and the SDLP are also aware of this, given that they also have a member, Mark Durkin, who sits on the Policing Board. And I will also remind the SDLP that their member constantly highlights that there must be a separation between the DOJ and the Policing Board when it comes to our powers and role. But I think it's important that today that we all get on the same page and we use all our powers necessary to ensure that we have confidence in the PSNI by journalists and the press overall. I want to highlight that we are in possession as Policing Board members of the report from the PSNI, and to confirm that at Thursday's private Policing Board meeting we will hear from the Human Rights Advisor as to his assessment of the report, and we will be able to ask questions of the PSNI. As I mentioned at the previous board meeting in May, the board meeting in April, I will call for that report and any subsequent report to be made public, and thankfully the Chief Constable has said that where they are in the capacity to do so, they will. I will also be proposing at the board meeting that we seek regular updates from the KC himself But we do have to be careful to ensure that this is not a policing board review, and that we, as a policing board, will still retain powers under Section 59 and Section 60 to call an inquiry or to ask the relevant ministers or Secretary of State to do so if we think advisable. To be clear, Alliance through the Policing Board have robustly challenged the PSNI and Chief Constable about dragging their feet on disclosing information to the IPT. I also want to thank the Minister, who has said that nothing is off the table when it comes to her powers of calling an inquiry or asking others to do so. I want to refer to comments that were made by some others and also about the inaccurate comments that were made by Colin McGrath regarding the Northern Ireland Policing Board marking their own homework because the Policing Board was in situ at the time of the PSNI using their powers. But the Policing Board has been in existence since the very day that the PSNI was established, and so will always be in situ when the police use operational matters or take operational decisions from any time after that date. So I don't understand that issue, but I hope that the member from the SDLP will get on board at the Policing Board meeting this coming week so that we can have consensus right across the team, both political and independent members, as how best to deal with this. I want to thank the members for bringing the issue forward, and I look forward to engaging as a Policing Board member in the future.
Matthew O'Toole.
Thank you, Mr. Speaker. I welcome the fact that we've had broad consensus on the importance of a free press, and indeed broad consensus, or relatively broad consensus, on the unacceptability of what happened to Barry McCaffrey, Trevor Burney and other journalists operating in Northern Ireland. We know now that inappropriate surveillance happened of those journalists, and there are very real concerns about the breadth and depth of the surveillance of others, journalists and lawyers. That is the core issue we are discussing here today. Sometimes amid the back and forth on scrutiny, responsibility and statutory powers, it can be lost that the core thing we are debating is protecting and defending the freedom of the press in this society. And as I said in my remarks at the start, we have a particular duty in this chamber and in Northern Ireland to guard jealously the freedom of the press, not just because we are a society coming out of conflict, but because we are, according to RSF and others, among the most dangerous places for journalists to operate in Europe. We have a particular challenge around our defamation regime and the use of slaps, as was said by my colleague Patsy McGlone, to silence legitimate public interest journalism. Those are structural problems which exist in this society. When you layer onto that the routine surveillance of journalists doing deep investigatory work, that is an unacceptable situation. So we should not cavil or quibble about the seriousness of this situation. Add to that the fact that the heinous Legacy Act, which I hope will be repealed by an incoming government, the heinous Legacy Act, will place even more burden on public interest journalism. I will give away in 1 second to Mr. Carroll, to get to the heart of some of the darker recesses of what happened during our conflict, including actions by the state and paramilitaries, and that was what Barry McCaffrey and Trevor Burney were doing with no stone unturned, which led to some of these revelations in the first place. I'll give way to Mr. Carroll.
Member, forgive me, would you share my concern that this could extend beyond journalists? There could be troublemaker activists, troublemaker MLAs, troublemaker campaigners. We don't know how far this goes, and further endorsing the need for an inquiry. Would you agree with that assessment?
As I like to think that I myself would be thought occasionally to be a troublemaker. I would wear that with a badge of honour, but I think it's important that we do get to the heart of whether this has been happening on a routine basis and whether it goes beyond journalism. I just want to respond to a few of the comments, and obviously I'll pick up on particular comments in relation to the amendment and to the amendments. As I said at the beginning, our desire is to get to the right outcome here. It's not simply to make a political statement. Stuart Dixon said, and his comments were reflected by other Alliance spokespersons, that there was a need to follow due process and a need to respect the process that was laid down. And it's of course important, and of course the actual Alliance amendment itself asks us to welcome assurances, asks us to effectively defer to the existing process that exists. I acknowledge that there is a process there at the Policing Board, and I'll come on to say what we think around that amendment and around the actions of the Policing Board and where the Policing Board might go from here. But I do want to make the point. Part of the reason why we put down the amendment with the motion in the first place and asked for the Justice Minister to take some accountability of this was not simply to play ministerial politics. It's because we can't simply defer to due process in relation to this. Due process, as it were, kind of got us into this situation in the first place. Barry McCaffrey and Trevor Burney probably wouldn't have found out that they were being surveilled had they simply followed due process and just taken the word of authorities for it. So yes, it is important to give the Policing Board their head and to give them their role in all of these matters. And I'll come on to our reflections on the amendment on the basis of that. Linda Dillon also asked the question, who else did the PSNI surveil? And that is, again, why I think ultimately, unless there is a robust independent inquiry that comes out of the Policing Board process, and I hope there is, because that would be the first port of call, but unless there's a robust independent inquiry, statutory inquiry that comes out of the Policing Board, I think there will need to be, the Minister may need to step in and set it up. Why do I say that? I say that because a couple of people have said today that the Chief Constable, whom I have respect for, particularly given his record in relation to Canova, has set up an independent review. It is independent in the sense that it's not being set up by, he's not doing it himself, literally himself, or other PSNI staff aren't doing it, but it's not wholly independent in the sense that it's not set up on an independent statutory basis under the auspices of the Inquiries Act, and it's important to say that it is a review, and I recognise the huge stature of the people, Alison Kirkpatrick, Daniel Holder, Nuala O'Loan, very serious people who are advising on this, and those are people I think we can all be confident in. But it's not, and these people themselves, including the CAJ and Amnesty, have acknowledged it is not yet an independent statutory inquiry, and I think that may be where we ultimately need to get to. Peter McReynolds talked about us undermining the Policing Board. I do want to slightly push back on this idea that by having this debate today and asking the Justice Minister to account that this is somehow undermining the Policing Board. And this is notwithstanding the fact that in this current context we are not minded to divide on the alliance motion. I do not accept the idea that we're undermining the Policing Board by having this debate in this chamber now. I think that's frankly churlish in response to this debate. I will take an intervention, yes.
We'll note that my colleague didn't say that this debate today undermines the Policing Board, and in fact we welcome healthy debate on the matter because it is important that public attention is drawn on the issue, but actually you will recognise that there is a role from the Policing Board and you yourself, your member is not here in the chamber today, but you also have a member on the Policing Board who recognises too that the issue is important to be discussed at the Policing Board itself. Of
course I've acknowledged the role of the Policing Board. The point I was making is that this is a chamber where we're all elected to debate vital matters of the day, and there will be a role, I believe, should the Policing Board not be able to take this forward, there not be consensus at the Policing Board, or the Policing Board doesn't feel it has the budget, for example, and I know that has been a specific issue that has been raised, where there will be, I think, a role for the Minister. And let me acknowledge that I welcome that we got clarity from the Minister in her remarks that she is willing to, as it were, go there, should that be required, and I think it will be on all of us to hold her accountable to those remarks, but also before then hold the PSNI and the Policing Board accountable for the process that emerges in the coming days and weeks around the independent review by Mr McCulloch KC with the advice of the panel that I've mentioned. I just want to go through some of the other comments that were made and respond to them. My colleague Patsy McGlone highlighted the industrial scale, and he's right to say the industrial scale of spying that happened here, and I think that word is important. This isn't simply one discrete example. We don't know, to use that cliche, we don't know how far or how deep this goes. Patsy also acknowledged, and I'm going to repeat this point, about there is a degree of hypocrisy sometimes. People in public life here talking about press freedom whenever certain people have used some of those powers in terms of the defamation regime to silence public interest journalism. But I think that point was made clearly and distinctly. I just want to come on to the Justice Minister's remarks. I welcome the fact that the Justice Minister gave us a very clear overview of the legal position in relation to RIPA, the Investigatory Powers Act, the oversight role of the Investigatory Powers Tribunal, and the fact that yes, of course, those are accepted matters. The reason why she is named in our motion today is, I think, in a sense, vindicated by the fact that she has come and given us a detailed explanation of the legal position and acknowledged that should there not be a satisfactory outcome or a clear, robust, independent process and an inquiry that emerges, should that be necessary, that emerges from the policing board, that she is willing to take the necessary action to set up an independent inquiry, acknowledging that she may need legally to ask others, be they in the UK government and particular departments in the UK government, to set up an inquiry. I acknowledge that and I welcome that, and I think that proves that it was worth having this debate and worth having the Justice Minister accountable in this particular motion. Yes, of course, the SDLP is proud of our work in terms of developing the policing board and the recommendations of the Patton inquiry. It is not our role to undermine or question the role of the policing board. But there are real questions about the ability and the budget of the policing board to take this forward. We hope to see that accountability emerge from the policing board. I have very little time, but I'm happy to give way very briefly.
Would the member accept, though, that those strains and stresses in terms of budget also apply to the department and indeed to every part of the justice system?
I, of course, acknowledge that there are pressures on the budget. Let me say this. We cannot let this debate go by and let this issue pass by without acknowledging the seriousness of it. We need proper, robust, independent investigation to get to the bottom of this. Should that require an independent inquiry, ultimately, I will call on the Justice Minister to work with colleagues, whether that's budgetary or anything else, to set that up.
Seat, please. Question is the amendment stand in the name of Nuala McAllister, Stuart Dixon, Peter McReynolds and John Blair be made. All those in favour say aye. Aye. Contrary, if any, no. The ayes have it. The ayes have it. The question is that the motion is amended be agreed. All those in favour say aye. Aye. Contrary, if any, no. I think the ayes have it. The ayes have it. Next item on the order paper is an opposition motion on hate crime legislation in Northern Ireland. I'll ask the clerk to read the motion.
That this Assembly notes the alarming prevalence of hate-motivated crimes in Northern Ireland and across these islands, recognises that legislation governing hate-motivated